We all hope to age. We all hope that we're going to have a long life. And therefore, we should all expect that at some point, even if it's only for a short period of time, we're not going to be able to make decisions for ourselves. And we want to make sure that there's somebody there we trust to make those decisions for us.
Hello, I am Celia Sanka, Executive Director of the DiversityCanada Foundation, and this is the goldenvoices.com Golden Years Fireside Chat. This is where we focus on issues of importance to seniors under the theme of living longer and living well. On this edition, we will be speaking with Douglas Elliott, Dr. Doug Elliott. Hi, how are you today?
I'm good.
Yes, I remember when I said that recently, Dr. Douglas Elliott, you had, you informed me it's not medical.
I'm not a medical doctor. No, I'm a doctor of laws, honorary doctor of laws. So I am Dr. Elliott, but I won't be writing anyone any prescriptions. And we're going to be talking about some healthcare issues today. So I just want to make it clear to the audience that I'm not qualified to give medical opinions, just legal opinions.
And that is a big thing, actually, because it's this past June, just last month, Doug, who is an Elliott Laker, received a rare honor among the legal fraternity. That's the Law Society of Ontario presented Doug with an honorary LLD with something like 57,000 lawyers in Ontario. Only about 4 per year get that Doctor of Laws conferred on them. So that's a major, that was a major honor. So I feel proud that an Elliott Laker has that wonderful distinction. Doug has been practicing law since 1984. He was called to the bar then. He is a partner at Cambridge LLP, the law firm, and his practice has encompassed a wide range of complex business litigation, including cross-border litigation, alternative dispute resolution, estates and trusts law, and it's the estates and trust law that we will be focusing on. His experience is really broad and significant. His experience includes winning the largest class action trial judgment at the time in an action that was brought by a group of gay and lesbian Canadians seeking CPP survivors' pensions against the federal government. We'll be focusing on issues of importance to seniors in terms of estate planning and legal matters. When we begin to look at planning for your, estate planning, there's something that comes up that's significant, and that's mental capacity and consent. Would you set the ground for us by explaining why that is so important in terms of seniors?
Right. So there are two distinct concepts legally, and they are both legal concepts rather than medical concepts, but they are linked to your medical condition. Capacity is about your ability to process information and make important life decisions in a variety of settings. That can include decisions about your health care, can include legal decisions like making a will. And then we have the related concept of consent. And consent obviously comes into the picture in other settings as well. It can, such as consent to sexual activity, But typically what we're talking about in the context of seniors is consent to healthcare decisions. And the reason that both of these issues are important to seniors is because as we age, if we're lucky enough to age, there is an increasing likelihood that we're going to be suffering from physical, neurological, or mental health conditions that are going to affect our ability to make important decisions, and therefore are going to affect our legal capacity or our ability to consent. And therefore, anyone who's entering their golden years should be aware of these issues, and as should people who care about the people who are entering their golden years. Because, of course, if we are lucky as we age, we have people around us who love us and care for us and who want to look out for our well-being. And that includes being alert to issues of capacity and consent.
What does it mean specifically when someone is said to be mentally incapable? Are there specific things that this applies to?
Capacity is a legal question, and it is very contextual, and it also is not something that is necessarily fixed. If you think about it, lots of us go through situations where we are temporarily incapable. So, for example, if you're having a surgery, you could be sedated, and while you're under sedation, you're not capable of making any decisions for yourself, and you need someone to be able to make those decisions. Sometimes people have conditions such as depression, where they may be incapable for a period of time when they're severely depressed, and then when they recover, they're capable again. Unfortunately, sometimes people have either permanent impairments, perhaps because of something like a stroke, or they have a degenerative condition where over time, something like multiple sclerosis, for example, where over time their brain function will be affected and they can lose capacity on a permanent basis. So whether you are capable or not also depends on the context of what is the type of decision that you're being asked to make. So, for example, you could be capable of making a decision about activities of daily living, what to wear, what to eat, where to sleep, those kinds of things. But it may be that you're suffering from a condition that makes you incapable of more complex decisions. How to write a will, how to, what to do about a lawsuit that you're facing, or of course, healthcare decisions. Whether or not to have surgery, whether to take medications for a mental health problem. Those types of decisions require a high level of functioning. And sometimes people either temporarily or permanently are incapable of making those types of decisions for themselves. So a finding that someone is mentally incapable of making that particular decision means that someone else has to make that decision for them. And there are several pieces of legislation in Ontario that, and every province has its own, but in Ontario there are several pieces of legislation that could come into play where someone is found mentally incapable. And those include the Healthcare Consent Act, which governs healthcare decisions, the Mental Health Act that deals with situations where someone is getting psychiatric treatment, and the Substitute Decisions Act. And the Substitute Decisions Act is kind of the catch-all for any other kinds of decisions where you are found mentally incapable. the way the law works is that the law has always been aimed to protect people who become, we've always recognized legally since the law existed that there are people who either temporarily or permanently can lose their capacity. And the law always makes sure that there's someone there to help the person to make this important decisions for them in their best interests. The law will then provides a framework to determine, first of all, whether the person is incapable. Gives people in some circumstances an ability to challenge or resist that finding if they don't agree that they're incapable. And if they are found incapable, determines who it is that's going to make the decisions on their behalf. Because who makes those decisions depends very much on the question of what has to be decided. It also is determined in Ontario and other provinces based on what you yourself have done to prepare for that situation where you may become incapable. And all of us should be thinking about that. You know, we all hope to age. We all hope that we're going to have a long life. And therefore, we should all expect that at some point, even if it's only for a short period of time, we're not going to be able to make decisions for ourselves. And we want to make sure that there's somebody there we trust to make those decisions for us.
In terms of that assessment that someone is mentally incapable, who makes that? Can the kids get together and say, Mom is, showing signs that she cannot take care of herself, so we, as the kids, we love her, we decide that she is not capable of making these decisions anymore, and we're going to move her to a long-term care facility. Is that how it goes?
Not exactly. People have this idea from the movies and popular literature that, you know, your family can have you committed. That it doesn't quite work that way. We now have procedural safeguards in place. Who makes the decision about whether you have capacity depends very much on the context of what's going on. So, for example, if you are in a hospital and you need health care, it is the healthcare provider who makes the decision initially about whether or not you have the capacity. It's up to them to figure out whether you have the capacity to make a decision about your health care. And then there are procedural protections in place to make sure that you have a right to challenge that decision and that the correct person steps in if you don't challenge the decision. So the person you've chosen, there's always a default public official. In Ontario, it's the public guardian and trustee. So if you have no family members, there's no one you trust, there is a government official who will step in and make those decisions for you so that you're not left without someone to protect your interests. If you are being asked to draft a will or make another legal decision, it's the lawyer's responsibility to make a decision about whether or not you are capable of making that legal decision. If someone asks me to bring a lawsuit on their behalf, I have a duty as a lawyer to figure out whether they are mentally capable of making that decision. And, mental health problems are far more common than people realize. And these issues come up in my practice all the time, not just with seniors, with all kinds of people. But with seniors, of course, you have to be especially careful because the older someone gets, the more likelihood there is that they're going to have a condition that could cause a problem. And the greater the likelihood that if they make a decision that someone else doesn't like, that there's going to be an allegation that they didn't have the capacity to make that decision. Fundamentally, though, under the Substitute Decisions Act, if you have a genuine concern about someone's incapacity, then you can take steps to have a capacity assessment done. A capacity assessment is done under the Substitute Decisions Act, and it is done by a professional capacity assessor. These are people who are properly trained and who are recognized by the government as being able to determine whether or not someone has capacity. A question that I get frequently in those circumstances is what happens, to use your example, what happens if mom says, I refuse to be assessed? Can you do anything about it in those circumstances? And the answer is yes, you can in some circumstances. So in Ontario, under Section 78 of the Substitute Decisions Act, a capacity assessor, when they are asked to do a capacity assessment, must have the consent of the person who's being assessed. If the person being assessed refuses to be assessed, the capacity assessor is required to stop. They're not allowed to proceed with the assessment without consent. However, if the family members become aware of this and they still feel an assessment is vital, they can make an application to the court. And a court, a judge, can examine the circumstances under Section 79 of the Act. And under Section 79, if the judge is satisfied that there's a reasonable grounds to believe that the person may lack capacity and that the determination of their capacity is necessary for the purposes of the Act. So, for example, if someone is trying to have themselves appointed as guardian, what a lot of us know about the Britney Spears case and the conservatorship that was her father got. Well, in Ontario, we don't call it conservatorship, we call it guardians. So if one of the kids in your example wanted to be appointed as guardian of mom, and mom said, there's nothing wrong with me, and slammed the door in the face of the capacity assessor, then if there were grounds to believe that mom lacked capacity, the children could go to a judge, and if they were able to persuade the judge that mom had problems and that it was important to determine whether one of the kids or a group of them should be appointed as mom's guardians because she lacked capacity, then the judge could order an assessment of mom, and that judge could make whatever terms that she saw fit to impose in that order, including, if necessary, the judge could order mom to be physically brought to the assessor for the purposes of the assessment, if that's necessary. Now, generally, our judges will, they'll always try and use the least draconian, the least harsh measures possible. But, sadly, you do get situations where people have serious mental health problems that they cannot that are so bad that they can't recognize the fact that they have these mental health problems, and the only way to get them the assistance they need is through coercive measures. The other route for family members who are concerned, so the Substitute Decisions Act procedure that we were just discussing, that's for a situation where you think mom is not able to look after her affairs anymore. She's not paying her bills, and or she's not looking after herself, and you want to be able to look after her, get her admitted to a long-term care facility, or you want to be able to look after paying her bills because she keeps forgetting to pay the hydro and it keeps getting cut off. These are the kinds of things that a guardianship is for. Now, the other type of situation that comes up is when people have mental health problems and they're not getting assistance for them. Let's say mom is the concern is not that mom is not paying the hydro bill, but rather that mom got depressed when dad died and she's not getting psychiatric assistance, and she's becoming very reclusive and isolated, and things are looking pretty grim for her mental health. In those circumstances, under the Mental Health Act, the family can seek to have a psychiatric assessment done, which is different from a capacity assessment. And they can go to a justice of the peace and seek the issuance of what's called a Form 2 under the Mental Health Act. And under that form, the police could apprehend mom and take her to a doctor where she could be examined to determine whether she's suffering from a mental illness that puts her health in jeopardy or puts her life in jeopardy. If the kids were concerned that mom was actually suicidal because of dad's death, that would be the appropriate procedure to follow under the Mental Health Act. So which procedure you follow depends very much on what the problem is that you're facing, and what problem you're trying to solve. Are you just trying to get mom some psychiatric treatment? Are you worried about her paying her bills? Or do you think she just, it's a situation where she just can't live on her own anymore, but refuses to admit it because she's got some kind of psychiatric impairment? The psychiatric impairment could be a mental health problem, but it could also be caused by physical conditions. For example, diabetes is a very common condition in older people, and diabetes can cause depression. And so sometimes these mental health conditions have a underlying physiological problem that is causing the mental capacity to become compromised.
Wow, that is, that's getting it real. Yes, sometimes we cannot even conceive that that's where some of the things that you have to grapple with in older age. But thank you for bringing that to the fore, that these are some situations that families have to deal with, even where you have to resort to the court or to the police, where things are a little tougher to deal with than one would hope. Now, families can try to avoid things getting there by the senior. So seniors can avoid getting into scenarios like those by taking matters into their own hands at an early stage and appointing individuals in their lives that they trust to handle decisions for them. Tell me a bit more about the idea of a substitute decision maker and how a senior can set that up.
So there's basically three kinds of substitute decision makers. The best kind of substitute decision maker under the Substitute Decisions Act is the person that you choose yourself. So it's not always obvious who the person is going to be that you're going to choose. You may have 3 children that you love. One may be the person who is really good with money and who you trust to look after your money, but that person may not be very in tune with your moral, religious, or philosophical beliefs. They may not really understand what your views are about end-of-life decisions, for example. And So it may be that you've got another child who is the one who really is on the same wavelength with you on those issues, but is maybe not very responsible financially. So under our law, we have two different kinds of powers of attorney that are recognized. One is for property, and that's to deal with financial decisions. And once the person who holds that power of attorney is the person, if you are found incapable, they are the person who will step in legally to look after your bills, to sell your house if it has to be sold, that sort of thing. Then we have the power of attorney for personal care, and that is the person who makes a decision about treatment and whether you're going to have treatment or not. And that's also, of course, for seniors, that's a very important one when it comes to end-of-life decisions, because that's the person who's going to make the decision about what are often called heroic measures in the medical context, is when what types of treatment should be withheld depending on the circumstances. So the power of attorney for property is one that should be chosen based on the person's familiarity with your financial situation and their skill in looking after money. You know, my brother has an MBA, is a much better choice for looking after my mother's money than me. The other issue, though, with respect to healthcare, that's one that I think it's very important for the senior to talk to the person who they think is going to be the person who gets the healthcare power of attorney, to make sure that they're on the same wavelength, you know. I saw this unfold with my own parents. You know, my father was a fairly pragmatic person who believed that there came a point where you should stop with the heroic measures and let nature take its course. And my mother was the kind of person who was going to keep him alive at all costs, regardless of the circumstances. So she wasn't a very good choice for him for the power of attorney for personal care. So that's very important decisions. And the great thing is that it's a decision you get to make yourself. You get to choose. The law doesn't impose anything on you. If you don't choose, and you are mentally incapable, then the law will look to the people who are closest to you. They will look to your spouse. They will look to your children, your parents, your brothers and sisters, and they will find the person who's closest to you and seek to have them make the decisions for you. Now, that person will not be appointed without their consent, but the law doesn't like a vacuum. And so if you haven't done this yourself, someone will be chosen. And it may be that it's going to be your sister Mary that you haven't spoken to for 10 years because she's the only one she's the closest related to you. And you may not want Sister Mary making those decisions for you, because she may decide that, she may make decisions that you don't like at all. She may decide that she'd like to use that money that you have set aside for a Caribbean vacation for herself. So that's why it's important you make the decisions yourself. If the law cannot find a power of attorney, and the law cannot find a close relative to choose to make the substitute decisions, then there's a public official called a public guardian and trustee. And they have a staff of people who look after incapable people for a living. That's what they do. They're professionals, and they will make decisions based on what they think is best and wisest for the person, depending on their circumstances. So they will choose a nursing home for you. They will decide whether to have a medical procedure. In those circumstances, healthcare, they usually listen to what the doctors have to say. But I think the average person would prefer not to have the government looking after their money or making healthcare decisions for them. And you can avoid that by dealing with it yourself beforehand. And I hasten to add, by the way, I think a lot of people are under the impression that lawyers are really expensive, and they can be, there's no doubt. But powers of attorney are not very expensive. The average Canadian can easily afford them, and it's far wiser to spend the money on a power of attorney in advance than to leave a mess that results in a big court battle afterwards among your family members or with your spouse. And I see them all the time, especially because it's very common now, Celia, for seniors to be in very complex family arrangements as they age. They may be living with someone who's a same-sex partner, but they're still married to their husband, and they've got children that they had with their husband, but they now have the children of their new same-sex partner. And if they don't address those issues in advance, boy, the knives come out in a hurry when things go wrong, and then you get into very stressful and very expensive court battles. They are to be avoided. I know I'm trying to put myself out of business by giving that advice, but believe me, it's way cheaper to spend the money in advance and make your own decisions instead of having a judge make them for you when your family are fighting about it afterwards.
Yes, things can get really messy when we're speaking about money and family and different interests conflicting at a moment like that. And so, Doug, you pointed out there are two different types of power of attorney. One deals with property, and another one deals with care decisions. In terms of care decisions, if we focus in a bit more on that, there is also something I've heard about called a living will. What is that exactly?
A living will is a term that's used for what lawyers would more properly call an advance directive. So you can, if you have someone who is your attorney for personal care, there are a couple of ways that you can restrict their ability to make decisions for you. You can, in a power of attorney for personal care, say, for example, you can make decisions for me, but you're not allowed to make decisions about terminating hydration, or you're not allowed to make decisions about terminating a feeding tube. Or, there's certain things, if you feel strongly about certain things, some people have a horror of amputation. I will never allow you to have an amputation. So there's those kinds of restrictions that can be put into a power of attorney. But a living will is more typically thought of in terms of an advanced healthcare directive that tells the attorney and constrains them to stop providing health care in certain specified circumstances. And typically what people are concerned about is circumstances where they're near the end of life and a major intervention has to happen, and they don't want to prolong their suffering, or they don't want to risk very negative consequences. And so they want to tell the attorney and the healthcare providers that are taking instructions from the attorney that they have to go by what the person has directed, and they're not allowed to administer healthcare except in accordance with those instructions. So, and typically this is a do not resuscitate order is what we're talking about, is DNR order, that when a person is in a very fragile condition, sometimes they know if you have I went through this with my own father, that if you have a serious medical condition, that my father had a number of heart attacks, and we knew if he had one more heart attack, if they intervened to resuscitate him, that he might not survive. He would be very traumatized by the resuscitation process. And if he did survive, he probably was going to have a severe brain damage that was going to leave him severely impaired. And he didn't want that. He didn't want to live with a severe brain impairment. And so he gave an advance medical directive saying, if I have another heart attack, don't try and save me. That's it. My mother didn't like it much, I can tell you, because she wanted them to intervene. But those were the instructions he issued. As it turned out, he recovered, and we never had to act on it. But the instructions were there because those were his wishes. He was very clear about it. In fact, he made sure that I witnessed those instructions because he didn't trust my mother to carry them out.
That's pretty interesting. So this living will, that advance care directive or advance directive, it can include things like blood transfusions, whether to have one or not, dialysis, certain drugs as well?
Absolutely. It can contain a whole range of directives. So, of course, some people don't want blood transfusions for religious reasons. And that one's clear enough. Historically, blood transfusions were given far too liberally, and there is a certain amount of danger associated with blood transfusions. So it is a very personal choice about whether or not to have a blood transfusion, or an organ transplant, or amputation is a big one, I know I had an uncle who was subjected to flesh-eating disease. And the only way to save his life was to have his leg amputated. Now, he made the decision himself. He was competent to do it. But that was a very difficult decision to make about whether or not to have that amputation. It worked out for him. But some people it's a profound decision. It has life-altering consequences, whatever you do. And so some people will want to have very specific instructions about those kinds of things. But I find that the one that people are concerned about most is being in what is called a persistent vegetative state, where their body is alive, but their brain is not. There's no, the lights are on, but nobody's home. And people can live in that situation for a very long time. They have a healthy body. Their body can carry on for years with their mind totally gone. And there's a lot of people who really don't want to be in that situation, and they don't want their family to have to care for them in that situation. It's obviously very stressful for loved ones when someone's in that kind of condition.
So the way to take care of that is, as you said, there are two ways: either to include it in the power of attorney for personal care, or have both a power of attorney, which just says, this is the person I appoint, and a living will or advance care directive that limits what the power of attorney for personal care, whoever has been appointed or given that power, can do.
Right. And as I say, for most of us, these are very profound decisions, and not everyone sees things the same way. Some people have no problem with blood transfusions, and some religious groups like Jehovah's Witnesses, is the famous one, they don't. They have a religious horror of receiving blood transfusions, and that ought to be respected. That everybody has to make their own decisions about these profound medical questions and philosophical questions too, about when does life end?
Now, you had mentioned earlier that there are two types of power of attorney, one for personal care, which we've just been discussing, and then there's the other power of attorney, which takes us into matters of financial decisions. If I'm not mistaken, there are, under that type of, the financial assets, there are two types of power of attorney, one that continues if you're incapacitated and one that stops when you become incapacitated. Is that correct?
Well, again, it depends on what you say. So the good thing about powers of attorney in Ontario, and I think most provinces, is that now, it used to be in the old days that if you became incapacitated, the power of attorney ended and then you had to run off to court and get a judge to decide what was going to happen. Now the power of attorney, if it says that it continues after you're incapacitated, then it does continue after you're incapacitated. But you do have the right to limit it to situations where you still have capacity. The old concern, just so we're clear, I mean, some people may think, well, that's silly. Why wouldn't you want it to continue? The theory was that you might change your mind. And you might decide, oh dear, my wife's left me. Maybe I don't want her to have the power of attorney anymore. And if something happened to you, that she would then be able to go wild with your money, and that would be a terrible thing. So that's why the law used to require you always to go to court. Not anymore. Now you can say that it continues even in the event of your incapacity. And that's what most people do. I should also mention that quite apart from the general power of attorney for property that we're talking about, lots of times individual financial institutions will have their own forms, and they will have what we would call a limited power of attorney. So it may be that you want to have your son to be able to pay your bills for you, but you don't want him to be able to sell your house out from underneath you. And so lots of times what seniors will do in those circumstances, they'll set up a bank account that has a limited amount of money in it that they'll use for household expenses. And they'll give a power of attorney, a bank form of power of attorney, to their son so that the son can make, deposit their pension check and pay their hydro bill and so on, but can't, take off with all their money. And that's a very common situation. And I will say that the financial institutions like banks, trust companies, investment houses, usually they are a lot happier when you use their form of a power of attorney. So sometimes people end up with a bunch of different powers of attorney just because they have to. It just is easier to use the forms that institution require. Although, if you have a proper general power of attorney for property done by a lawyer, it shouldn't be necessary to have a bank form. But I often tell people that it pays to do it because it just goes easier and faster when the bank sees it's in their own form.
Once you've chosen someone as to act on your behalf, someone has the power of attorney, does that person have to be paid?
They don't have to be paid, but in theory, they have a right to compensation. They have to go to court to have that compensation approved on what's called a passing of accounts. But in theory, the person is entitled to be paid. Just like an executor of a will is entitled to be paid. And the only way you can avoid that is by having a contract with the person who received the power of attorney where they agree not to charge a fee. And I always think it's a good idea to clear that up with the person ahead of time, because that also can cause court fights and hard feelings, that sometimes the daughter who's looked after mom's affairs for 10 years wants to get some compensation for her trouble, but her brother is outraged that she's charging anything to dear old mom. And of course, the outrage is really that it's going to reduce the amount that he receives. But that's something that's best dealt with by agreement in advance. And you can make, and sometimes people do the opposite, and they'll put right in the power of attorney, my daughter Jane is to receive compensation in the normal way for the time she spends looking after my affairs under this power of attorney. Sometimes people will do that instead of getting a guarantee of no charge. But it's something that people would do well advised to clear up in advance with whoever's going to do it. Because, sometimes you're doing this for a very short period of time. You're just looking after somebody's bills for a few weeks while they're in hospital. But sometimes, if people have chronic Alzheimer's, something like that. I know one of my relations lived with Alzheimer's for, I think it was 20 years. And so, a family member had to be looking after their finances for 20 years. Well, that's a lot of work. And to expect someone to do that for free is, I think, a little unreasonable. Whereas if it's just for a few weeks and it's a family member, well, maybe you won't, you wouldn't expect any compensation.
Thank you so much, Doug, for sharing your insights. There's one thing I wanted to ask, one final question I had as we close, and that is where should someone keep their advance directive, their living will? It does no good to have it in a drawer somewhere in the basement.
I've got to tell you, this is, I remember... or any important legal document like that. I remember one of our neighbors died in Elliott Lake, and the widow told me, he has his will, it's in a safe deposit box. I said, which bank is it at? She said, I'm not sure, but the key is in the top drawer of his dresser. And I went into the top drawer of his dresser, and the entire drawer was full of keys. He had worked as a security guard. There were thousands of keys in the drawer. So where you leave it is very important. It should be kept someplace that's fireproof. It should be kept in some place where the person who is going to be acting on that power of attorney or advance directive knows where it is. That's super important. So if you name your daughter Jane to be your power of attorney and there's an advance directive, send her an email, send her a letter, tell her, I keep this in a lockbox that I keep on the top shelf in my bedroom. You will find the key to the lockbox on the key ring where I have my car keys. That will save people an enormous amount of grief. It's got to be kept in a safe place. It's really not a good idea to keep it in your safe deposit box unless the person who is the subject of the power of attorney and has access to that safe deposit box, because sometimes you need to act on that power of attorney or advance directive quickly. And if it's a Friday night, you might not be able to get through to the bank until Tuesday, and that may be too late by then. And, things may have moved on in a way that you wouldn't be happy about. So keep it accessible, safe, but most importantly, the people who need to know about it, your next of kin or your power of attorney, they need to know where it is and be able to get access to it quickly.
Is this also something that you can share with your primary healthcare provider?
Yes, indeed. You can let your family doctor know. And I would say that for the average person, the family doctor probably doesn't want to be bothered with it. But if the family doctor knows that you have a degenerative condition, like multiple sclerosis or Alzheimer's, they probably do want to know about it and do want to have it in their file. Or if you're going for a major surgery, you're going like my father was for a triple bypass, and you might not survive or you might be severely impaired, then they will want to know.
Very good advice. Thank you very much, Doug, for everything that you've shared today. Thank you for taking the time out of your busy schedule to help seniors understand about these important, these crucial legal issues. They have vital importance to seniors.
Thank you for having me, Celia. It was a pleasure.
The pleasure is mine and ours here at the DiversityCanada Foundation. I am Celia Sandker. I'm the Executive Director of the DiversityCanada Foundation. We're the organization that brings you the goldenvoices.com website, where you'll find this interview as part of our Golden Years Fireside Chat and several other topics we cover in the Golden Years Fireside Chat, all of concern to seniors and under the theme of living longer and living well. See you next time. Thank you, and take good care of yourself. Bye for now.